what would the panel think about a system in which all lawyers who act for government or government instrumentalities refuse to appear in circumstances where the other side is incapable of affording a legal defence?
My response to that would be, I think I would consider that to be a pretty radical suggestion, but one which I think does force the issue, which is that access to justice does mean access to adequate representation. And if you cannot actually secure adequate representation, then actually the judicial process should actually halt at that point to ensure that you do get access to it.
Well, I'm not talking about the judge stepping in and saying we're not going ahead until both sides are represented, but those appearing for government saying we won't appear for you unless you will assist the other side to be represented, so that the governments can then see what it's like to be unrepresented in litigation.
I think that responsibility still is upon solicitors and lawyers, in a sense that you do hold the responsibility in many respects for the machinery of justice. You might point to a judge or a justice in that particular instance, but actually as lawyers you do hold that responsibility. Now I think that's a pretty brave step to take, but I think it would be an expression of commitment, I think, to see that the justice system is actually functioning on its base principles.
Hugh, what do you regard as the biggest single access to justice issue confronting Australia?
We need to really put scrutiny on the government to say, look at the level of representation that you ensure for yourself, and look at the level of representation you ensure for your citizens who can't afford a lawyer. So the federal government spends $722 million a year on its own lawyers. It's gone up about 7% over the last year. The federal government spends about $330 million on lawyers through Indigenous legal services, legal aid and CLCs, for lawyers for people who can't afford a lawyer in the community. So it's spending more than twice as much on its own lawyers than it is for people who can't afford a lawyer. And ensuring for itself, QCs, instructing solicitors, best legal advice possible, while ensuring for the people who can't afford a lawyer, you basically have to be on a poverty level income to be able to access legal aid on an income and means test, have low assets, and then you can only get legal aid for serious crime and some family. I better revise. It's very limited family law now. We need to look at this unequal representation. So coming back to your question, I'd probably say the biggest issue facing us is that the promise of equal access to the law is a myth. So we have two standards of access to justice in Australia. Justice for those who can afford a lawyer and justice for those who can't, or who can't access the limited community legal service, legal aid, CLC. So the Chief Justice of the West Australian Supreme Court said it well when he said big business can access the courts but the ordinary Australian can't.
What can we do to increase access to justice?
Well, I think, following on from what Hugh has said, there needs to be an urgent increase in funding, both at a state and a Commonwealth level, and the changes that have happened just in the state of Victoria, and Hugh mentioned some of them before. I mean, last year there was a 4.7% increase in crime. It's the first time that crime has gone up in a number of years. That means about 30,000 new initiations in state courts. That means you've got that many more people who want representation to lawyers. There's about a 27% increase in the reports of family violence. Again, that's people coming before courts who need lawyers. There's more notifications in the child protection system because we've got more child protection workers, which is a good thing. But again, they're people that need representation. So when we think about government policy, what I wish is that the impact that government policy is going to have on legal assistance be part of every equation. So even if we think recently about the promise to implement the National Disability Insurance Scheme, which is an absolutely fantastic thing, and we commend it, and VLA is a supporter of the Every Australia Counts campaign. But when that bill came out, there was a specific clause in the National Disability Insurance Bill that precludes funding, legal assistance funding for people who want to challenge their eligibility to the scheme. So you can review decisions, much like you can review decisions under the social security legislation, but they're not going to fund legal assistance service providers to do it. Now, in terms of good administrative justice, it is absolutely crucial that you ensure sort of transparency and good primary decision making by having a well-funded review system. That is an example, I think, of how the impact on legal need or the impact on legal assistance just gets left out of the equation when we think about how social policy or how government policy is being implemented. And so I think that's one of our real access to justice issues, that we've got to get legal issues, legal assistance and the lack thereof in the forefront of sort of every piece of government policy and understand what the consequences are going to be of it. The other thing that I would say is that we talk a lot about access to representation and whether people are eligible for a grant of aid or not, and that's extremely important, but there are other access to justice issues, and the first thing that someone needs to understand is that they've actually got a right to, or the issue that they're trying to deal with, or the problem they're trying to deal with, has a legal dimension. So a whole bunch of people out there, depending on whether it's a social security matter, a discrimination matter, a debt, a tenancy matter, may not know that that thing that they experience as a life problem has a legal dimension and there may be a legal resolution to it. So access to justice for me starts at information and education of communities, and that requires the thinking about the importance of CLC work or legal aid work or even pro bono work, not just representation in court, but getting out there into marginalised and vulnerable communities and helping people understand that they have rights and how to access them, and also the people they might come into first contact with, whether that's GPs or social workers, getting them to understand that the people, there's the law survey that I referred to earlier, reported that it's only, I think it's like something like 6% or a really low percentage, 6 to 13% of people will contact a lawyer at first instance if they have a legal problem. People are more likely to tell their GP or their social worker or a teacher. So we have to get people to understand, people who are working with our clients at that level as well, that there are good referral places to send people to and to do, kind of basic legal rights education for the people that are working with our vulnerable communities.
Everyone recognises, I think, that the law is very extensive and legal aid funding is grossly inadequate. The unmet demand is probably greater than pro bono help will ever manage to fill. One question has been sent in is, do we need more alternative dispute resolution forums, more specialist tribunals and more innovative legal solutions rather than more legal aid and more pro bono time?
I think yes. I think mediation, alternative dispute resolution, all of those things are admirable and a really good way to actually stop people ending up in courts, noting that 95% or something of cases settle before they end up in court anyway. However, I think one of the main problems is, and specialist tribunals where you don't have to be a lawyer, what ends up happening is it is lawyers who are in there anyway. Sure, they have to seek leave to appear, just like non-lawyers have to seek leave to appear in the courts. But it ends up being very legal in any event. So what you end up with is a situation where you've got a specialist tribunal, which is supposed to be non-legal, actually being totally populated by lawyers, which, with the inevitable consequence that it becomes a specialist quasi-non-legal kind of tribunal. So I think all of these things are admirable ideas, and I think they should be absolutely encouraged. And certainly when I practiced in commercial litigation, there was very much a push towards mediation and alternative dispute resolution before you end up in court. But it also still seems to me that in those 13 years that have passed, that hasn't really picked up a lot of the dispute resolution in the broader terms in the way that it was anticipated when those reforms were brought in.
What recent legislative changes have significantly increased the demand for legal services?
Well, there's been a number. So move to baseline sentencing, changes to community correction orders, changes to the way in which family violence operates. There are a higher number of PSOs, so protective services officers. The introduction of protective service officers was also meant more initiations, more criminal initiations, more handing out infringement notices. Then on a national level, we had mandatory sentences for people charged with people smuggling offences. And that legislation has now been overturned, but I suppose they're just sort of an example of some of the recent pressures that have translated into, or some of the recent policies that have translated into pressure on the system.
Speaking in the broadest terms, what are the main areas of community justice needs that you come across, Hugh, and you come across, well, I guess legal aid, Kristen. What are the big ticket items, the large volume things where lots and lots and lots of people actually need help but can't get much?
One of the big things for us, and Hugh and I were actually part of a session last year, it's probably not the first thing that you'll think of. We run a legal help service that takes about 100,000 calls from the public every year. The first top thing that people call about is parenting issues, so custody issues, child arrangements, family violence issues, and the second is employment. So we have the highest, we're the most casualised nation in terms of employment in any sort of Western nation. So we have a huge number of people in insecure or casual employment, and there is a paucity of funding or information or assistance for people who have employment law problems.
I think I said before that I think employment is the number one, and I was a national spokesperson for a campaign around access to justice last year, so I travelled around the country and talked to colleagues in access to justice services, and employment law kept coming up time and time again as the greatest area of unmet legal need. I just wanted to link that back to what we were saying before about pro bono, and just to quash the myth that pro bono can be a substitute for legal aid or adequately funded legal aid. If you look at pro bono surveys, employment law is the first or second top area of assistance provided. So it makes sense. Firms have got capacity in employment law, there's expertise there to help everyday people. So there's a lot of work done in employment law by firms. Conversely, employment law is one of the top issues for turn away by firms for pro bono for reasons other than means or merit. So while there is capacity, it's getting turned away time and time again because there is insufficient capacity.
Most people, I think, reckon a free or substantially government subsidised health system is an essential part of a civilised society. No one, or very few people, suggest that similar thinking should be applied to law, and I think the reason for the distinction is that you can't help if you get sick, you can help whether or not you go to law. That's presumably, there's some element of choice. That seems to me to be a complete fiction. Most people haven't got any choice about whether to go to law.
And particularly when you consider the relationship between getting sick and legal issues arising from there. So what the law survey showed us was that particular, and other surveys from the UK showed us, is that particular life events trigger legal issues like relationship breakdown, unemployment, ill health. So to sort of suggest that you blame people for these issues that trigger legal problems is ridiculous. And we've been arguing the same way that we need to look at a universal health or education system. We need a universal access to legal assistance for those who can't afford it.